Freedom of speech is the right to communicate one's opinions and ideas without fear of government retaliation or censorship. The term freedom of expression is sometimes used synonymously, but includes any act of seeking, receiving and imparting information or ideas, regardless of the medium used. Governments restrict speech with varying limitations. Common limitations on speech relate to libel, slander, obscenity, pornography, sedition, incitement, fighting words, classified information, copyright violation, trade secrets, non-disclosure agreements, right to privacy, right to be forgotten, public security, public order, public nuisance, campaign finance reform and oppression. Whether these limitations can be justified under the harm principle depends upon whether influencing a third party's opinions or actions adversely to the second party constitutes such harm or not. Governmental and other compulsory organizations often have policies restricting the freedom of speech for political reasons, for example, speech codes at state schools. The term offense principle is also used to expand the range of free speech limitations to prohibit forms of expression where they are considered offensive to society, special interest groups or individuals. For example, freedom of speech is limited in many jurisdictions to widely differing degrees by religious legal systems, religious offense or incitement to ethnic or racial hatred laws. The right to freedom of expression is recognized as a human right under Article 19 of the Universal Declaration of Human Rights and recognized in international human rights law in the International Covenant on Civil and Political Rights. Article 19 of the ICCPR states that everyone shall have the right to hold opinions without interference, and everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing or in print, in the form of art, or through any other media of his choice. Article 19 additionally states that the exercise of these rights carries special duties and responsibilities, and may, therefore, be subject to certain restrictions, when necessary, f. or respect of the rights or reputation of others, or f. or the protection of national security or of public order, or of public health or morals. Origins. Freedom of speech and expression has a long history that predates modern international human rights instruments. It is thought that ancient Athens' democratic ideology of free speech may have emerged in the late 6th or early 5th century BC. The values of the Roman Republic included freedom of speech and freedom of religion, right to freedom of speech and expression. Concepts of freedom of speech can be found in early human rights documents. England's Bill of Rights 1689 legally established the constitutional right of freedom of speech in Parliament, which is still in effect. The Declaration of the Rights of Man of the Citizen, adopted during the French Revolution in 1789, specifically affirmed freedom of speech as an inalienable right. The Declaration provides for freedom of expression in Article 11, which states that the free communication of ideas and opinions is one of the most precious of the rights of man. Every citizen may, accordingly, speak, write, and print with freedom, but shall be responsible for such abuses of this freedom as shall be defined by law. Article 19 of the Universal Declaration of Human Rights, adopted in 1948, states that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. Today, freedom of speech, or the freedom of expression, is recognized in international and regional human rights law. The right is enshrined in Article 19 of the International Covenant on Civil and Political Rights, Article 10 of the European Convention on Human Rights, Article 13 of the American Convention on Human Rights and Article 9 of the African Charter on Human and People's Rights. Based on John Milton's arguments, freedom of speech is understood as a multifaceted right that includes not only the right to express or disseminate information and ideas, but three further distinct aspects: the right to seek information and ideas, the right to receive information and ideas, the right to impart information and ideas. International, regional and national standards also recognize that freedom of speech, as the freedom of expression, includes any medium, be it orally, in written, in print, through the internet, or through art forms. This means that the protection of freedom of speech as a right includes not only the content, but also the means of expression. Relationship to other rights: the right to freedom of speech and expression is closely related to other rights, and may be limited when conflicting with other rights. The right to freedom of expression is also related to the right to a fair trial and court proceeding, which may limit access to the search for information or determine the opportunity and means in which freedom of expression is manifested within court proceedings. As a general principle, freedom of expression may not limit the right to privacy, as well as the honor and reputation of others. However, greater latitude is given when criticism of public figures is involved. The right to freedom of expression is particularly important for media, which plays a special role as the bearer of the general right to freedom of expression for all. However, freedom of the press is not necessarily enabling freedom of speech. Judith Lichtenberg has outlined conditions in which freedom of the press may constrain freedom of speech. For example, where the media suppresses information or stifles the diversity of voices inherent in freedom of speech. Lichtenberg argues that freedom of the press is simply a form of property right summed up by the principle, no money, no voice. Democracy. Freedom of speech is understood to be fundamental in a democracy. The norms on limiting freedom of expression mean that public debate may not be completely suppressed even in times of emergency. One of the most notable proponents of the link between freedom of speech and democracy is Alexander Meiklejohn. He argues that the concept of democracy is that of self-government by the people. For such a system to work, an informed electorate is necessary. In order to be appropriately knowledgeable, there must be no constraints on the free flow of information and ideas. According to Meiklejohn, democracy will not be true to its essential ideal if those in power are able to manipulate the electorate by withholding information and stifling criticism. Meiklejohn acknowledges that the desire to manipulate opinion can stem from the motive of seeking to benefit society. However, he argues, choosing manipulation negates, in its means, the democratic ideal. Eric Barrett has called this defense of free speech on the grounds of democracy probably the most attractive and certainly the most fashionable free speech theory in modern Western democracies. Thomas I. Emerson expanded on this defense when he argued that freedom of speech helps to provide a balance between stability and change. Freedom of speech acts as a safety valve to let off steam when people might otherwise be bent on revolution. He argues that the principle of open discussion is a method of achieving a more adaptable and at the same time more stable community, of maintaining the precarious balance between healthy cleavage and necessary consensus. Emerson furthermore maintains that opposition serves a vital social function in offsetting or ameliorating normal process of bureaucratic decay. Research undertaken by the Worldwide Governance Indicators Project at the World Bank indicates that freedom of speech, and the process of accountability that follows it, have a significant impact in the quality of governance of a country. Voice in accountability within a country, defined as the extent to which a country's citizens are able to participate in selecting their government, as well as freedom of expression, freedom of association, and free media, is one of the 6 dimensions of governance that the Worldwide Governance Indicators measure for more than 200 countries. Against this backdrop, it is important that development agencies create grounds for effective support for a free press in developing countries. social interaction in community. Richard Moon has developed the argument that the value of freedom of speech and freedom of expression lies with social interactions. Moon writes that, by communicating, an individual forms relationships and associations with others, family, friends, co-workers, church congregation, and countrymen. By entering into discussion with others, an individual participates in the development of knowledge and in the direction of the community. University of California, Los Angeles Chancellor Gene Block issued a statement concerning both the value of free speech and the responsibility for civil discourse. The statement was in favor of an environment in which people coming from different beliefs and backgrounds may engage in passionate dialogue without belittling one another. In Block's view, just because speech is constitutionally protected doesn't mean that it is wise, fair, or productive. Limitations. For specific country examples, see freedom of speech by country, and criminal speech. Legal systems recognize limits on the freedom of speech, particularly when freedom of speech conflicts with other values or rights. Limitations to freedom of speech may follow the harm principle or the offense principle, for example in the case of pornography or hate speech. Limitations to freedom of speech may occur through legal sanction or social disapprobation, or both. In On Liberty, John Stuart Mill argued that there ought to exist the fullest liberty of professing and discussing, as a matter of ethical conviction, any doctrine, however immoral it may be considered. Mill argues that the fullest liberty of expression is required to push arguments to their logical limits, rather than the limits of social embarrassment. However, Mill also introduced what is known as the harm principle, in placing the following limitation on free expression: the only purpose for which power can be rightfully exercised over any member of a civilized community, against his will, is to prevent harm to others. In 1985, Joel Feinberg introduced what is known as the offense principle, arguing that Mill's harm principle does not provide sufficient protection against the wrongful behaviors of others. Feinberg wrote, "It is always a good reason in support of a proposed criminal prohibition that it would probably be an effective way of preventing serious offense to persons other than the actor, and that it is probably a necessary means to that end." Hence Feinberg argues that the harm principle sets the bar too high and that some forms of expression can be legitimately prohibited by law because they are very offensive. But, as offending someone is less serious than harming someone, the penalties imposed should be higher for causing harm. In contrast, Mill does not support legal penalties unless they are based on the harm principle, because the degree to which people may take offense varies, or may be the result of unjustified prejudice. Feinberg suggests that a number of factors need to be taken into account when applying the offense principle, including the extent, duration and social value of the speech, the ease with which it can be avoided, the motives of the speaker, the number of people offended, the intensity of the offense, and the general interest of the community at large. In 1999, Bernard Harcourt wrote of the collapse of the harm principle. Today the debate is characterized by a cacophony of competing harm arguments without any way to resolve them. There is no longer an argument within the structure of the debate to resolve the competing claims of harm. The original harm principle was never equipped to determine the relative importance of harms. Kurt Westergaard, a Danish cartoonist, created the controversial cartoon of the Islamic prophet Muhammad wearing a bomb in his turban, and because he expressed his opinion, he met with strong violent reactions from Muslims worldwide, including Western countries. Westergaard has even received numerous death threats and murder attempts from Muslims, even though he used his right of freedom of speech, since he lives in a society where this right exists. He was harassed by people who were intolerant of criticism. Similarly, Noam Chomsky, the MIT professor and vociferous critic of Israeli and U.S. policies, has received numerous death threats. Interpretations of both the harm and offense limitations to freedom of speech are culturally and politically relative. For instance, in Russia, the harm and offense principles have been used to justify the Russian LGBT propaganda law restricting speech in relation to LGBT issues. A number of European countries that take pride in freedom of speech nevertheless outlaw speech that might be interpreted as Holocaust denial. These include Austria, Belgium, Czech Republic, France, Germany, Hungary, Israel, Liechtenstein, Lithuania, Luxembourg, Netherlands, Poland, Portugal, Slovakia, and Switzerland. Norman Finkelstein, a writer and professor of political science, expressed the opinion that Charlie Hebdo's abrasive cartoons of Muhammad exceeded the boundaries of free speech, and compared those cartoons with the cartoons of Julius Streicher, who was hanged by the Allies after World War II for the words and drawings he had published. In 2006, in response to a particularly abrasive issue of Charlie Hebdo, French President Jacques Chirac condemned overt provocations which could inflame passions. Anything that can hurt the convictions of someone else, in particular religious convictions, should be avoided, Chirac said. In the U.S., the standing landmark opinion on political speech is Brandenburg v. Ohio, expressly overruling Whitney v. California. In Brandenburg, the U.S. Supreme Court referred to the right even to speak openly of violent action and revolution in broad terms. Our decisions have fashioned the principle that the constitutional guarantees of free speech and free press do not allow a state to forbid or prescribe advocacy of the use of force or law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or cause such action. The opinion in Brandenburg discarded the previous test of clear and present danger, and made the U.S. citizens' right to freedom of speech almost absolute. See First Amendment to the United States Constitution for more detailed information on this decision and its historical background.